good afternoon, good evening, wherever you're joining us from. Welcome to this second conversation in our series on the future of open source, brought to you by the UCLA Institute for Technology, Law and Policy, a new research center whose mission is to foster research and analysis to ensure that new technologies are developed, implemented, and regulated in ways that are socially beneficial, equitable, and accountable. And by Corporate Accountability Lab, an international human rights organization that uses design thinking and legal design to hold companies accountable for crimes against people and the environment, and by the Organization for Ethical Source, which believes that helping open source communities center equity and justice, meaningfully empowering technologists from traditionally underrepresented or undervalued groups, and focusing on real-world impact are key to unlocking the incredible potential of open source to drive lasting change and promote broad social good around the globe. My name is Michael Karanicolas, and I'm the Executive Director of the Institute for Technology, Law and Policy. On behalf of all three organizations, I'll begin by acknowledging UCLA's presence on the traditional, ancestral, and unceded territory of the Gabrielino Tongva peoples. We have an incredible panel today to discuss the role of ethical provisions in open source and their relation to broader moves in support of open access and tech accountability. Sameeul Haque is an intellectual property and human rights attorney at the Corporate Accountability Lab, where he heads the ethical IP program. He's also the author of Hippocratic License 3.0, a new ethical open source software license available on OES's website, ethicalsource.dev. We'll put that in the chat later. Prior to joining Cal, Sameeul was a commercial litigator in the Chicagoland area. He graduated from Chicago Kent College of Law in 2019, where he now teaches and coaches trial advocacy. Luis Villa is a co-founder and general counsel at Tidelift. Previously, he was a top open source lawyer and an experienced open source community leader with organizations like the Wikimedia Foundation, and he has counseled clients such as Google on open source licenses and technology transactions, and Mozilla, where he led the revision of Mozilla's public license. He served on the boards of the Open Source Initiative and the GNOME Foundation, and been an invited expert on the Patents and Standards Interest Group of the World Wide Web Consortium and the Legal Working Group of OpenStreetMap. Luis holds a JD from Columbia Law School and studied political science and computer science at Duke University. Karen Sandler is the executive director of Software Freedom Conservancy and previously the executive director of the GNOME Foundation. Before that, she was general counsel of the Software Freedom Law Center. Karen co-organizes Outreachy, the award-winning outreach program for women globally and for people of color who are underrepresented in US tech. She's also a recipient of the O'Reilly Open Source Award. And I will be moderating this session myself. The timing of this session is quite opportune, I think, because of the recent launch of version 3.0 of the Hippocratic License, which itself leads to natural and important questions about the interplay between human rights norms and open source principles. Given that timing, we are, I think, very fortunate that Sam, the lead author, the lead developer of this license, is here with us. So I think perhaps that's a natural place to start with some commentary from him on that project and its underlying goals.
Thank you very much, Michael. I appreciate you having us and obviously organizing this with Cal as well. I will link a PDF of the current version of Hippocratic License 3.0 in the chat. When we developed this license, we kind of had three major goals in mind. The first one, we felt like the current slate of ethical licenses, some of them were very targeted towards very specific causes. You had the 996 license, which targeted labor practices. We saw the atmospheric license, which talked about environmental issues. And we thought that there needed to be one that provided a great baseline of human rights protections and outlined them very, very clearly. So that was part of what we did, and the human rights norms that we selected were based off of the UN Declaration of Human Rights, the International Covenant on Economic and Political Rights, and various other treaties, along with the International Labor Organization's ILO indicators. So again, we use a lot of human rights norms that are seen in the industry in order to develop these standards. The second thing we wanted to accomplish was, having what we believe to be as strong of an enforceable ethical license as we could possibly have. Obviously, you don't really know enforcement until it's tested within the court system, but we wanted to develop one that we felt at least confident that it would be enforced within the courts, and we think that it's the most enforceable amongst the current slate of ethical licenses. And finally, we wanted one that still offered software developers a level of freedom to choose some of the specific human rights causes that they felt like they wanted to champion. And so we offered additional modules, which were additional ethical standards that software developers could then add for unique causes. And those causes could range from environmental protection to the boycott, divest, sanctions movement with respect to Israel and Palestine, to boycotting the Taliban or the military junta in Myanmar, all sorts of international conflicts, as well as domestic issues as well. And so we felt that this freedom that software developers had to be able to add causes that they felt like deserved additional attention or more protection was something that we could offer as well. And it allows the license to grow as it's continued to be used in the future.
Thanks. That's super interesting, and there's a lot to dig into there. I want to turn it over to Louis to offer you, if you want to present your sort of general thoughts on the question, as well as specific thoughts on the centralization and decentralization aspect that Sameeul brought up. Which I think is relevant to both the core question around ethical source licenses, as well as I think the engagement of the broader open source ecosystem.
Yeah, I think there's two real. I think there's a couple real challenges with the increasing diversity of open source and the increasing, literally just size of open source that make ethical licensing really challenging. And the first one is, we just heard a long and good list of things that we should all aspire to, not be doing a bunch of these things that were just mentioned, right? And yet at the same time, our sense of how these are implemented in national legal systems is a really challenging one, right? We got away with this for a long time in the history of free and open source software because the Berne Convention, and for those who are not lawyers in the audience, I'll say that the Berne Convention is an international copyright convention that essentially all countries on earth, I think maybe there's like one or two that still haven't signed on, but that gives an international baseline for what copyright law is supposed to be. Now, there are a variety of deviations across countries, many of which are not relevant to software, but an increasing number are relevant to software. But this sense that there was an international baseline, the programmers will recognize this as a shared platform, right? Something that has shared definitions, shared concepts, that when we were building the early free and open source license concepts, we could say, well, we're building one license for the entire globe because the entire globe recognizes copyright. And the entire globe more or less agrees on what copyright is. Of course, as with any shared platform, there are implementation details that have been tricky over time. But there was this core shared legal concepts, right? As we get into ethical source, there are some core concepts, right? We can get into UN Declaration of Human Rights, but their implementation, but exactly how agreed they are is actually, as we all too unfortunately know, very varied. How they are translated into domestic legal systems varies from fairly rigorously to not at all to never even attempted. And so trying to build one license that can work across all these different legal conceptions of ethics, moral and religious and political and economic conceptions of ethics, is a much trickier challenge, and I think that I think that shows up in a variety of ways in execution, right? It shows up in licenses that are either woefully incomplete or trying to boil the whole ocean. It shows up in questions of as we were just hearing, it shows up in questions of enforceability, right? Of like, okay, well, this might work in the US legal system. Will it work in the Kenyan legal system? Will violations, and I don't mean to pick on Kenya as any particular, but pick any place where you think that human rights violations are going on that are mediated by software. Translating those is tricky. The other thing, and I'll try to be a little briefer about this one, is simply at the beginning of free and open source software, we had a shared ethical vision, right? We thought we were making the world better by sharing software. And there is now a much broader sense of what does it mean to be ethical in software, right? If I publish software under a license that allows anybody to use it, under a traditional conception of free software, there was very much this sense of like, well, anybody can use it. That's a good thing, even if occasionally it's used for bombing or tracking immigrants so that we can expel them, or any number of bad things that gets done with software, because it turns out almost all bad things are done with software now, right? Because all things are done with software, therefore all bad things are done with software. That's I think an ongoing discussion that these licenses have inserted themselves into the definition of, but we don't really know where that discussion is going. Many people have a broad difference of opinion on it, and so the licenses inevitably, not necessarily in a bad way, right, but are very squarely in the middle of this very tumultuous discussion of which licensing is only one part.
Yeah, that last point that you meant, I mean, there was a lot of interesting stuff there, but that last point that you made about what does it mean to be ethical in software, and these kinds of questions that folks are asking is I think like really cuts to the core of this conversation, of this issue, and I think that's a great place to turn it over to Karen, and I can maybe ask your kind of initial thoughts on ethical licensure, as well as the broader idea of technological neutrality within open source.
Sure. I want to just take a quick step back and do first of all, you may have noticed that I have dialed in to Zoom using phone rather than using the proprietary Zoom interface. My interest in free and open source software freedom, comes from a really personal place. I have a pacemaker defibrillator, and I can't see the source code in my own body. And the way that software has functioned over the course of my life hasn't matched up to my needs. Because I'm not, for example, I was shocked unnecessarily when I was pregnant, because pregnant women tend not to have these devices. So it gives me a really personal viewpoint of how we use our software, why we need software transparency, and why we need control over our software. And all of that comes through an ethical lens. And so it's deeply personal for me that I won't use proprietary software whenever I can avoid it. And I think that it's really important that we try to move as many of these conversations about the future of software freedom or open source to places where we have open source and software freedom. So I'm going to not moralize about it, but it's tough, and I apologize for missing any of the verbal cues as maybe everybody is rolling their eyes at me. But to answer the question at hand, one of the things that we do at Software Freedom Conservancy is we enforce the GPL, one of the most or the family of the most prominently used Copyleft licenses. And I love that it seems like Copyleft has been so successful that we want to use that as a model for other licensing. But I have to share with you that, I heard Sam saying you don't know about enforcement until it's tested in court. And that's totally true. But even for licenses that have been tested in court, where the licenses are found to be enforceable, we still have mass violations throughout the industry. I would say that it's so bad that the proposition of copyleft has never been tested, because we don't actually know what it would be like to have an industry or a technology industry where people actually have access to source code, where we can take our critical software, move it to other systems, and control it and improve it. And I think that this really goes to the areas where the ethical clauses in these licenses can be problematic, because many of them are trying to underscore or to prevent activities that are already illegal and not permitted. And the problem that we have enforcing copyleft licenses is that companies do everything they can to hide this. And at the end of the day, you can't sue every company. You don't know what's going on, and you have very little insight into the companies. Now, we at Conservancy bring lawsuits, and I think we're working to help that. But that's just one of the major reasons why I think I'm not sure that this is, while I think that we need to find ways to compel software to be developed in an ethical way and to be used only for ethical purposes. This has been my hesitation with the licensing all along. And Lewis said that, we had a shared vision when we started making free and open source software licensing, but I don't think that's actually, I don't agree with that. I think that we thought we had a shared vision. I think we ideologues thought that we had a vision across the board, and that by sharing software we would get to an ethical place. But instead, I think a lot of us thought that we could really have a benefit from, we mixed up the interests of our employers with our own interests, and we missed an opportunity. And now we've largely abandoned copyleft or allowed copyleft to be violated. And where copyleft could be used for ethical purposes, we've completely avoided that. So I think that I applaud these exercises in drafting these licenses and exploring this. I've personally published a blog post about bringing ethical provisions into employment licensing agreements, where the employees who actually wind up seeing these violations of human rights are empowered to do something about it, because that's, to me, the real tension point and where we can do something about it.
Thank you so much, Michael.
Oh yeah, I was just going to say I have prepared questions, but I think that this is a great place to just pass it back to Sam and to Luce, because I think that I'd be really interested to hear what you have to say to that.
So I did want to say that to Karen's point about how that there's a lot of experimenting with respect to software licenses. I think software just generally challenges how we view copyright law. I mean, a lot of what copyright law was meant to cover were things that were quite static, right? You talk about books or art, whereas software is something that it's constantly changing, especially in the open source community. So I think she's right to point out the idea that this is a lot of what we're doing right now, not just ethical software licensing, but software licensing generally is experimental. And us as lawyers are having a unique challenge in this realm to say, with this experimentation constantly going on, how do we use traditional contract law and traditional licensing to have some level of predictability in this realm? And obviously, where we're going to be a little bit more experimental, how do we combat that with respect to how do we develop our licenses, which was something that, we went back and forth with in the development of the Hippocratic license as well.
Yeah, and I think I'd add to that that I really take Karen's point about enforcement as, Sammy and I started with this, how do we write a license that's enforceable? That's like 5% of the problem, right? The other 95% is, as Karen correctly said, discovering violations, litigating over violations. Like, that is the hard work of, you can take a badly drafted license, and if there's like actually good discoverability and there's good litigators and well-funded litigators, like that's like a badly drafted license and well-funded litigators is probably better for enforcement than a perfectly drafted license with no litigation around it, right? And that's something that, as Karen can certainly speak to, that has come in waves, and I certainly take the point that a way that I have phrased this in some public presentations right before COVID was, that licensing is not a solution. Licensing is a tool that a broader movement can use, but it's probably not. I think maybe we have often told engineers that licensing is the solution, and that I think in retrospect was maybe a message that we a message that was a mistake, right? Or often, lost in the noise, right?
And to that point, I think it's important to kind of expand who can enforce licenses or what parts of licenses can be enforced. I think traditionally we've seen that as license assignments, right? Like, and not necessarily in this open source context, but we saw that a lot in patent litigation, where employers would have employees assign the patent rights to the employer, and then they would be the ones responsible for litigating it. We've seen it a little bit in the open source community with the development of commons, where IP is licensed, right? If you develop a software and have a license under it, you let somebody else enforce it. What we've tried to do with the Hippocratic license, which again is a little bit different, is allow the parties that are harmed by the ethical violations to then, have this expanded duty of care where, any licensee has a duty of care under the license to all of those within their supply chain, and they cannot violate the ethical standards as it relates to those people. So, for example, if you're an employee in a supplier for the licensee, and you are enslaved by that employer, well, now through this expanded duty of care model, the licensee owes a duty to you, and if that duty is breached, then you have a private right of action to the licensee. Now, that doesn't solve all of the issues that Lewis talked about with respect to discoverability. I think that there are still serious questions about that. You don't really know who is already a licensee and who will, continue to adopt it. These are things that are generally pretty private, but expanding the scope of who can sue, I think, is helpful in enforcement.
Yeah, Karen, I wonder what. Yeah, please.
I was just going to say, while there are other legal mechanisms for a lot of the behaviors that we're trying to prevent, the problem is that the folks that know about it, who would either share that information, are employees of companies, and we're looking for mechanisms by which to shed light on the situation and take action to prevent that behavior. But the problem is that those employees who are the ones who find out about the bad behavior aren't empowered. They have no safety in order to shine light on these issues. And so, I sort of feel like we need to really focus on that piece of it, because otherwise, I guess I've just seen the failure of Copyleft so many times, because there are only so many companies that we can go after in only so many ways, and to see how we have such massive roadblocks. It's, even though we have the breadcrumbs and we know what they're doing. So I just feel that way, and I think it's just really tough, because I want to come here and say, it's so easy to enforce Copyleft, which has inspired this, and that we're going to have an easy time about it.
So I think that you have made an extremely effective case for better whistleblower protection legislation. And on that front, I am strongly in agreement. That's something that transcends national boundaries. That's something where the US lags behind places like South Africa. There are a number of countries which provide very robust whistleblower protection legislation, not only for public sector whistleblowers, but also for private sector whistleblowers. And that is an area where there's significant need for legislative improvement. I'm not sure that, I guess what I would say to that is that doesn't necessarily, the need for additional forms of legislative protection to protect X wouldn't necessarily, I would think, impact arguments for or against a different area of legislative improvement or a different area of contractual improvement, what have you. And so, I would, I would think that those two tracks could potentially be taken forward simultaneously, and it's not right. It's not necessarily one detracting from the other. let me,
Though I think this
yeah,
points to one of the challenges for adoption, right? They're most certainly big early initial adopters of a lot of commercialized open source. Like for example, IBM jumped in early on to the use of the Linux kernel. Linux kernel being one of the first, for the lawyers who are here, being one of the first sort of big early open source, free and open source success stories. And but IBM did that in part because they had a large IP team, right, intellectual property legal team, who took the time to familiarize themselves and understand what they could and couldn't do. And I am certain, I've never heard an IBM lawyer admit to this, but I am certain that one of the risk factors that they took into account was, who are the potential plaintiffs? What would their, what are their incentives? What are their resources? And when and still it took some time and a lot of research and a lot of getting comfortable with it to wrap their heads around the GNU GPL, which is the license that the Linux kernel was under. IBM, I presume, also at this point probably has a human rights legal team, but I suspect not a big one. I suspect it's focused on other issues. And it's going to take a lot of time for companies to get comfortable with some of these things that simultaneously sound unobjectionable to the, like, we should probably not be enslaving people. Okay, but what about our supply chains? What do we think about, like, there's a lot of stuff, infamously, probably the first ethical license in this source was one that simply said, Karen, you'll have to grab me on the right phrasing, but don't be evil, right? Or don't do evil with this code. And that was it. And a lot of non-lawyers are like, well, that sounds easy. Don't be evil. And then you're like, okay, but how does that translate? If you're IBM size, what does that even mean, right? It's hard to turn that into like real world rules and real world actions, and that slows adoption. And on the one hand, maybe slowing adoption is okay, right? But on the other hand, if you want a real world impact, you do want some level of adoption, and swinging that needle or threading that needle of, okay, well, it's easy enough to comply with that a lot of people use it, but not so easy as to make it toothless, is a hard one to thread. And I think it's great that we're experimenting. I'm curious to see how that particular problem evolves.
Yeah, I want to present that point to maybe all to all three of you in turn, in terms of that potential trade-off between promoting innovation and access to technologies, as well as promoting the ethical use of these technologies, and the way that could potentially be understood or navigated in the context of open source, because I do think that there is a tension there. Maybe we'll go back to Karen and then to Sam to respond.
Sure. I mean, I apologize because I just want to clarify my point from earlier, because Sam, I agree with you that we need both tracks. You talked about two tracks where you defined, like, what I was talking about, whistleblowers as a second track, but I was actually advocating for a third track, which is really change from a labor side. So for tech workers to insist upon provisions in their contracts. And this comes from this idea in free and open source software that a lot of employees have asked to hold their copyrights for the work that they do, in the scope of their employment, which is, I think, unusual compared to other areas with respect to copyright. And so I think that if employees were able to get in their contract, their employment contract, the empowerment to whistleblow or take action in some way when they see these abhorrent acts, I think that could, that could really speedily bring across some ethical change. And why wouldn't large companies agree to have that unless they were worried that they were really, contributing to atrocities, right? So I feel like this is something that is right in front of us, and is something that we, with some significant degree of tech workers on our side, can actually start to accomplish, and it doesn't sort of upset this whole corporate legal realm around copyright licensing. So that was what I was advocating for. I mean, I think that free and open source software, especially Copyleft, has an ethical component built in, because if we have access to our critical technology, we are able to replace the software on those devices, which means we're able to reduce surveillance, which allows us to protect ourselves if we have the resources from oppressive regimes. It means that we're able to connect to individuals around the world, or groups that can help us to make sure that software is used for ethical purposes. And so I think that there is something inherently ethical about the strong use of Copyleft and the nonprofit organizational drive around free and open source software. And it's really this relationship with corporate open source where it becomes, and non-Copyleft licensing, where it becomes a lot more problematic, which really goes towards that neutrality question.
Yeah, I also very, very, very strongly agree with the potential value of empowering tech workers. I think that's an enormously interesting area of action. I guess the flip side to that is that responses from the corporate side, where we have seen worker actions in support of ethical causes, have not been very positive. I think there's tons of examples at Google, for example, of retaliation against whistleblowers, against people that have tried to push them in a more ethical direction. Just today or yesterday, I think it was, we saw that Facebook's reaction to leaks of some information, which I think, as a lot of folks rightly pointed out, shouldn't have been confidential in the first place, and that there was no real public harm to that getting out. And nonetheless, Facebook's reaction to the information getting out was to lock down internal discussion on these issues, with potentially consequences on their own ability to innovate and improve their civic engagement. But I need to cut myself off now, because I'm going to start ranting about Facebook and Google if I don't. So I want to turn it back to Sam for a response.
Yeah, and so I think Karen's point is the right one when we talk about the issue of corporate adoption, is to empower tech workers, right? And I think that the reason, Michael, to your point about companies like Facebook and Google kind of shutting the door and really having harsh responses to whistleblowers, is coupled with the fact that the tech industry has also generally not been big about labor movements generally, right? Like, they have heavily relied on independent contractors, and there's lots of benefits to employers as a result of that. And so I think that software developers, whether the independent contractors are working for companies, I think they'll benefit from ethical licensing, because once you hit a critical mass, you ultimately force corporations to then change. And we know that corporations can adopt very quickly, whether or not they want to or not. When the GDPR came out, I remember listening to attorneys going, everybody is having a firestorm trying to figure out what exactly they need to fix and adjust. And you don't hear about it anymore. So in a span of less than 5 years, everybody figured it out. And obviously there's still questions. Well, I see Louis shaking his head. When I say figured out, I mean, like, nobody is outwardly shouting, saying, like, what do we do in order to fix it? Maybe those conversations are far more internal, but nobody is having this mass scramble publicly to figure out how this law can affect them. And I think similarly, ethical licensing can have a similar effect, that if enough independent contractors and software developers adopt these types of licenses in their projects and force companies to say, look, if you want access to this valuable software, then you have to make these changes, or at least be aware of what your supply chain looks like, companies will adopt. Companies have in the past and will continue to do so, if there is a viable commercial interest, which will force them to do that. I think once you dangle that in front of them, they'll say, okay, sure, we have no problem making sure that we're not enslaving people, or we're not engaged in extrajudicial killings. But the reason companies are so reluctant to sign off on that is because they have engaged in that type of behavior, and there haven't really been any consequences for that. And whether software licensing should be the only answer, I think everybody agrees it shouldn't be the only answer, but it can be an answer.
So I think one of the sort of historical nuances here that I think it relates to the point I was making earlier about the growth and success of this is that there was a brief period where a lot of this work was done outside of the sphere of corporate influence, right? Where it was, companies like Microsoft really genuinely struggled to imagine that you could make an operating system on the internet, right? Like, it was so far outside of their realm of conception that they literally couldn't take it seriously. And then at some point they had to start taking the technology seriously, but they still took the movement. Somebody, actually one of our audience members, reminded me the other day of the existence of what were called the Halloween Papers, which were a set of leaked internal Microsoft memos where Microsoft essentially said, like, this stuff is terrible, it's communism. Like, they're a fascinating historical read, especially now that Microsoft publishes, amazing amounts of open source. And I wonder, I think it's an open question. I hope you're right on this, Sammy, but I'm not sure if you are. I think there's an open and interesting question about whether or not there is a space of open development that is vigorous enough and valuable enough to actually make the corporate world listen, right? Because there was this interesting window of opportunity where we made an operating system kernel that was really good. We made a database that was really good. I don't know if there's that next like opening where it can get good before corporate influence becomes too pervasive and nudges it in a direction that is safe for corporate use. Because I really think that's such a big, for better for worse, we live under capitalism. Like, it is what it is.
Right. I agree with that, because I think that, I'm sorry.
No. I was about to go to you. Yeah.
Okay, great. I think that Lewis is absolutely right, which is that the reason why Copyleft got successful adoption was because there was a tremendous amount of software already created from an ideological perspective that was just so good that companies had to use it. Even companies that called Copyleft an un-American cancer, I think it was. You can correct me if I'm wrong, Lewis. So, and I think that what happened is that it came out of this whole hobbyist space where people had a lot of control over the software and came together to create these incredibly useful software projects because it started with the software they were using to control their own devices. And so it wasn't from a corporate mentality because it was replacing the software that they received. And hilariously, a very high percentage of people now rely on devices that have the Linux kernel in it and should have the right to control and have the right to the complete and corresponding source code and the scripts to control compilation and installation of that software, but they don't, in practicality, have that access because they don't have, because nobody is following the rules with the licenses that we have now. And because we are not we're not resourcing and empowering the ideological movement and the nonprofit space that would be creating solutions that would create new useful projects that companies would have to use and that serve people who are being exploited by this technology. I think for me, like, I feel like, I desperately want this. I definitely want the Hippocratic license to succeed because I love what it's trying to do. I would love to see support also of the infrastructure that's already there and exploring a lot of ways that we can control our technology that would then create in us having a lot of useful software that we could then license and use in ways that are ethical and that we control.
So can I maybe frame that and throw it back to the other two as a question about existing power structures and whether or not, or I don't want to say I'm framing it, but I think that raises a particular question about the degree to which an enforcement model like this, which relies on litigation, which relies on resources and financing, which relies on groups to devote considerable time and energies to push for particular solutions, where those resources on the public interest side are scarce and get channeled in ways that can get channeled in ways that reflect particular interests. I wonder if I could ask, I guess starting with Sam, whether there is a challenge that the enforceability and the impact of this is not to say will reinforce particular power structures, but will channel along the lines of be channeled along the lines of existing power structures, and I think not necessarily impact some of the deeper structural challenges that I think, if I'm understanding it correctly, Karen is raising.
So I think that enforcement is always going to be a challenge, at least initially, right? And I think that's why it was so important for us to start with, do we have a license that we're comfortable saying is enforceable before litigation, right? And so that's why we wanted to stress so much in our development of this, to have what we believed was the best enforceable license amongst ethical licenses that were out there. Now, to the point about litigation and being a little bit resource strapped, like, yes, there is a level of resource strapping that occurs when you talk about litigation being the ultimate enforcement mechanism. But it's just the enforcement mechanism today. I was on a panel that's actually how I met Louis, was back in May, when we were talking about licensing in the open source space. And I brought up the idea that it would be great if eventually open source software developers could come together and kind of create their own arbitration body, right? Lots of organizations have done that. You see screenwriters are actually one of the first adopters of an arbitration body. And I think that if they are able to do that, then that could do a lot to decrease the cost of litigation while still having a similar impact on enforcement. Now, that's just in the United States, but we could see a lot of that in common law systems more globally as well. But there are other enforcement mechanisms, which is why the Hippocratic license doesn't specify an enforcement mechanism. It's just, any court of jurisdiction, and that includes arbitration bodies if both parties agree to that. I didn't want to necessarily demand arbitration right away. I think there's differing opinions on whether arbitration or other alternatives to litigation are actually cost effective. And that's kind of a separate whole other rabbit hole that we could, go down someday. But I think that, in order to curb the issues of enforcement and litigation, we need to start with creating a license that we believe is enforceable. And after doing that, then looking to alternatives. I think then the ideas of housing things under an IP commons, like we've seen some organizations do, or moving towards some type of arbitration or some type of organizational movement to have an alternative enforcement mechanism, is the next path forward.
I think that actually dovetails, maybe in a way that you didn't intend to, with this question about the existing channels of power. Because I think one of the things that we have seen in the existing space here, right, is that the vast majority of the lawyers who get to work on these kinds of issues on a consistent day in, day out kind of basis, the number who are actually employed by nonprofits cannot be much more than 2, right? I mean, literally it might be you 2, right? And there was a third at FSF. I'm really struggling. There might be a few more. Depends on how you categorize some of the people in Mozilla, maybe, right? Everybody else who has the privilege of working in this space on a day-to-day basis is, at the end of the day, paid to do this by extremely large corporate interests. And as a result, there is a lot of pressure, institutional power pressure, as you're saying, Michael, to round off the rough edges, right? And to not take, as you know, as lawyers, we're all sometimes conservative in good ways, sometimes conservative in bad ways. So there is very much a question of there is. I raised this question of arbitration on a mailing list of a lot of the key lawyers, and was just almost immediately shouted down, because corporate America only likes arbitration when it's an arbitration setup that deeply favors them, right? And if it's an arbitration setup, forget even a question of favoring, right? I think a lot of the people who are involved in this space are generally, by lawyer standards, extremely forward-looking, by lawyer standards, extremely generous, a really great community, like a genuinely great community of people. And if any of them are watching it, I say this with all due love, that like many of you are like deep old friends at this point, but at the same time there's this almost knee-jerk, if we introduce any uncertainty into the process it will be bad. And very rarely is the question asked, if we introduce any uncertainty into the process it will be bad for who, right? And I think for better or for worse, we, even again, those of us who are deeply thoughtful, caring, genuine people, over time, we often adopt the spoken and unspoken conventions of the people around us. And this gets back to your point, Michael, about power, of power works in both very overt and very overt ways, but also in very subtle cultural, social ways. And we create consensus in ways that can be really pernicious. And if there are any law students watching this, I absolutely urge you, think carefully about how, not just what the consensus is, but how it was created, who it benefits, because I absolutely think there's some great case studies to be written in this space about how consensus around some of these things has formed over the past 20 years, what that looks like, who it benefits. Again, even where every individual actor is like actually really genuinely positive, generous, almost to a fault.
And if I could spring back off of Lewis's point really quickly, that fear that corporations have about this idea of change ultimately, I think, allows litigation to still be a powerful tool, because there's a reason that there's not a lot of case law on software licensing, that a lot of, in generally in civil litigation, most cases settle is because the level of uncertainty and the fact that, at least in the United States, this idea that that we're not dealing with a particularly high burden of proof, right? This isn't beyond a reasonable doubt, right? This is preponderance of the evidence. And as a result of that, companies can be very scared of how litigation outcomes can impact not only where they are right now, but a ripple effect throughout the industry. So yes, we want to talk about how litigation often serves the more powerful because they have the money to spend, but all it takes is one of those cases to go to jury or to go to a bench trial and alter the way the industry is seen. And that fear of this change that could have these ripple effects, I think, is a legitimate one, and one that I think developers and adopters of the Hippocratic license can use to their advantage.
So
the field is rife with violations where courts have ruled licenses enforceable. So I agree with you. I mean, I agree with Lewis too about this idea of good intentions of the people in the field. I want to add that it's not just lawyers who were well-intended. It's also a lot of developers in this space who had the best of intentions. Many of them got started ideologically, and then they decided, they thought they could do well by doing good, right? They thought they could make a really good salary while contributing to the public good through free and open source software. And as Lewis said, they, rounded out the corners, right? And we've allowed corporate actors to co-opt the mission and message of software freedom, of free and open source software. We've allowed that to happen, and instead of software freedom, which should be, it's designed around the rights that go downstream, right? It's for developers to receive the software and for users, right? And it should be also for people who are impacted by the software, right? And so it's meant to be this downstream looking license, but instead, because of our lack of corporate accountability, it's been completely co-opted by free and open source software. And so there's a lot of it's been co-opted by corporations who are using open source and acting like this is this great thing that we're doing, and completely derailing the ethical mission of software freedom. And so, I think that it's about corporate accountability, and it's definitely about these power structures that you mentioned. And I think there is a place for many different paths that we need to pursue all at once, and we need to find the ways to empower as this software flows downstream to users and to people who are impacted by it.
Yeah, if I can, I want to echo and amplify one particular part of that, Karen, is that uh, I think I think one of the mistakes in retrospect that was made is there is an easy, I mean, literally, if you look at the history of the open source initiative, there was a point in time where when the open source initiative was first launched, they said, we are going to evaluate the project as a whole, right? What are your development processes? What are you going to do? How do you involve people? And then at some point they were like, oh, open source is growing so quickly that would just take too much time. So actually what matters is, or actually what we are going to evaluate, which slowly transmuted into this is what matters, right? Is what's the license? And this over focus on the license, and I think, the Free Software Foundation took a slightly different route but ended up in the same place, because if it had self-scrutinized its own governance and leadership, it would have failed a lot of tests. It would have failed a lot of its own ethical tests. So it too fell to, well, is it under the right license or not? Right. And this over focus on the license, I think, really, definitely, as I was saying, and as Karen was saying, corporate influence did a lot of that, but we certainly also did not help ourselves, right? We, those of us in the movement also were very guilty of over focusing on the license for a variety of reasons, which really helped corporations tell that story and skate away from the ethical obligations that we thought were part of the package. We thought the ethical obligations were inextricably part of the package, and it turns out they weren't.
But that doesn't, I don't think that necessarily means even if they were mistakes of the past, that we can't use them against corporations now, right? The reason the open source software movement has been so successful is because corporations found a way to be profitable off of it. It has become essential to the software ecosystem. And now that it's there, there are ways to use it as a mechanism to hold corporations accountable, to turn this machine that they've kind of created in order to derive profits for them against them, and ultimately hold them accountable in their actions moving forward.
I completely agree with that. But I would say that the open source movement was not successful. The movement was designed to give people control over their technology, and while there is open source in more products than you can imagine, in every development process, under every company, in every possible way, in every part of our lives, we have less control over the technology we rely on than ever before. You can't even, if you have a laptop, it's very hard to even have a completely free laptop or any appreciable control over any of the software that the average person uses. It's just, so I think actually the movement has, and it saddens me to admit it, but the movement has entirely failed. And I think the only way around it, truthfully, is exactly as you say. It's to take the system that we have put in place and to actually use it to empower people to take control of our technology that we deserve and that we have a right to as per the licenses that already exist.
Yeah, I think that's a really interesting point, and I think that it probably I think that absolutely holds true beyond. I think that holds true to our lives more broadly. That we have far less control over the products that we use and interact with on a day-to-day basis. I don't know. I'm not sure about 20 years ago, but certainly compared to 50 years ago, where now everything seems to be locked down with proprietary software and far more hostile to user customization, which certainly is an interesting impact that seems to be escalating now.
I happen to see, this is a little bit of a nice license nerd question, but Karen, I should literally send you this. Both of you, I should literally. I happened to stumble across a copy of the original IBM DOS license that was on the first computer that my family owned. It allowed modification of DOS. Right, like that was like that blew my, literally explicitly allowed, not even like a, oh, if you do a, like, it literally said you can modify this, which compared to the license that is wrapped around all of our phones, as Karen says, in some ways we've regressed. Karen, I think there's an interesting sort of historical point. The way I usually put this is that the open source movement actually did succeed, because I think a lot of the open movement, the founding folks, again, there's a historical dispute here, but the goal was corporate adoption, right? And I think the free software movement, the way I usually put it is that open source succeeded and free software failed. And I say free software failed for exactly the reasons that you're getting at, right? But again, in part, whether it's historical hijacking or it's actually true to the historical roots, this idea that we're all using open source, like, and it has not empowered us as users, but it has certainly empowered developers. And that gap, you could do a whole conference just on that gap of how did we end up empowering developers when we wanted to empower users, right? Because I think that's really, and again, Sammy, to your point, like, I don't mean to say that we shouldn't use licenses, but we have to properly conceptualize them as part of a toolkit, right? And I certainly think, what you all have done at the organizational ethical source, trying to build that into more than just a license, right? An attempt at like an institution and a movement, that's very much pointed in the right direction. Hard road to, lots of challenges in the way, no guarantee of success, but certainly you're trying to think bigger than just licenses, and I heartily endorse that.
Yeah, I want to make sure that we get a bit of time for audience participation and audience engagement, as we've had some really interesting questions come in to the chat. If folks would like to comment directly or engage directly, they're very welcome to use the raise hand function. But I want to put this question of developing a critical mass has been raised by Jeff Luz. I'm sure I am mispronouncing your name, and I apologize for that. Who says the GPL seems to survive due to the critical mass of the Linux kernel, and that it's commercially safe to reduce all the code of that layer instead of moving to a BSD or a parallel track. What ecosystems seem ripe for adopting an ethical license basis? And he suggests potentially machine learning as being one of them. Any thoughts on that?
Sammy, you're muted, but let me just jump in to say crypto is the Wild West. And actually, which is both, I mean, a lot of it's a scam, but there's a lot of interesting experimentation going on there, including the cryptographic autonomy license, which specifically has innovated and pushed in the area of data autonomy and empowering users through data and through privacy and sort of GDPR-like concepts. So I think that's an interesting venue to watch for where there might be critical mass.
Yeah, I kind of agree with Lewis. I think crypto is a great one. I also think that like companies that are engaging in SaaS or quantum computing services can also be really interesting in terms of incorporating ethical standards in their terms of service, which is a little bit of an odd switch. But in terms of specific ecosystems, I don't know if it needs to necessarily adopt into an ecosystem like the GPL did, but rather find the right project, right? If there's a critical enough project rather than an entire ecosystem to jump onto, I think that would be sufficient as a critical mass. It doesn't necessarily have to be 90% of developers using some form of the Hippocratic license. It could be, 0.3% of developers on the right project.
Yeah, I completely agree with that too. It's like the reason why Copyleft, why the GPL has been successful where it has been successful, is because the projects that were under those licenses became so useful that companies realized that they couldn't afford to not use them. Now, companies then spent a lot of effort writing alternatives to those copylefted programs, so that they wouldn't have to worry about their copyleft obligations for all of those same reasons. And so, what we've seen is the promotion of permissive non-copyleft licensing by companies. And I think it'd be interesting now to see how that would play out in an ethical source, scenario. I wonder if we would see the same issue, but I completely agree. Like what we need is for any licensing change is super valuable software that's licensed under that license. Doesn't matter what it is.
So we have a hand up, and it's one of our wonderful co-organizers, Caroline. I think you should be able to unmute yourself and ask.
Yes, I believe I'm unmuted.
Yep,
okay.
I can hear you.
One thing, just a couple of points I wanted to touch on real quick. First of all, that Ashley said, agreeing on an ethical framework would be very, very difficult, which is why we're pointing to, you don't have to solve every problem of ethics. We're not going to be able to do that. So we're very specifically relying on international standards as best we can. Again, allowing for lots of gray area. But in terms of adoption, I want to talk about that for just a second. And adoption of open source, the success criteria for an open source project is widespread adoption. You want the FANG companies, for example, to adopt your software. And the measure of success in open source is very much quantitative. Whereas the approach we see with ethical licensure, ethical licensure is not intended to take over the world in the same way that open source was intended to take over the world. Rather, what we're looking at is qualitative adoptions that actually do increase the leverage and increase the agency of developers downstream. And we can see that, we can see the ability to put pressure there on organizations like Palantir, which in the US provides essential services to immigration and customs enforcement. And we've actually written software that looks through their dependency tree and finds all the open source projects that Palantir is relying on to provide those services. So that kind of ties into like a supply chain issue, right? So we don't strictly have to rely on whistleblowers. We also have the ability to look at package dependencies. But the main point, qualitative over quantitative.
So I'm not sure if anybody wants to respond to that or jump in. I'll give it a second. Yeah.
No, I'll go and jump in. So I agree, obviously, with Caroline. I think the idea should be behind a qualitative version of adoption. I think if we're just looking at mass adoption, I think if an ethical license gets mass adoption by corporations, there's something wrong with the ethical license. And so I think we need to focus more on the qualitative approach, finding the right projects, making sure that the license does what we need it to do, whether that's the Hippocratic license or another ethical license that is solving a particular human rights issue or allowing a software developer to have some control over how their software is being used, that should take priority over an idea of mass adoption.
Yeah, I would also add that I think that there's as we've touched on in this panel quite a few times, there are a lot of different areas in which we're pushing for the same goals, whether it's through privacy, through software licensing, and copyright, or a variety of other employee empowerment and labor movements. While all these things should be operating at the same time, we need a lot more coordination across those different movements. Previously, we've all been sort of siloed in our own world. I've been working on a declaration of digital autonomy to try to tie some of these different concepts together. And I just think I just want to thank you all for this conversation, because I think having these conversations and bringing in the different perspectives and thinking across the stack of all the different legal mechanisms that we could use and how we can accomplish it, I think that's the only thing that's going to get us there in the long run, is if we try everything and we work all together.
Yeah, we have another hand up from Ashley Williams, who's also asked a bunch of excellent questions in the chat that I was going to get to next, but it's probably easier to just let her ask herself. Oh, Ashley, are you able to unmute? Let me try this.
Hello.
Hi.
Now,
yes.
The classic Zoom dance. Okay. Yeah, so I guess I was I had originally raised my hand to follow up on Coraline's point around the ethics. And I appreciate the sentiment that like, these are international human rights, like, can't we agree on that? Speaking from a maintainer's point of view, at least if I were to say, try and take a large project right now and convince the set of maintainers that we should say file under this license, I think it could be like really, really incredibly difficult. And particularly if the license isn't looking for mass adoption, I think that is potentially something that's going to make it even more difficult. Like the set of people, like developers who are contributing to things, and then companies that are using that software kind of rely on the fact that there's a couple of really well-known licenses and that they know how to deal with them. And most software, like when people are like shopping for open source licenses, they look for the ones that they understand and they know and have the lowest complexity, because the legal costs are incredibly high to even figure it out. So they want to go for something easy. And that's on both the developer and the corporation side. I love a lot of these goals, but I worry if you're looking for something that's not mass adoption, it's going to struggle to compete. And I do unfortunately think that we are in a situation where there's competition, because open source is this kind of like fascinating place where people aim for getting adoption and usage because it ultimately gets them value and resources in some way. Like the more adopted your library is, the better well known you are. It looks better on a resume. Your NPM downloads, like maybe that's how you get GitHub sponsors. So being able to get paid to do your work is really important. And so I think for people offering that software, it's going to be a real struggle to go, based on my ethics, I want to restrict the use of this, which I think is incredibly noble. But at the end of the day, it may just mean that nobody uses the software and then you have to go do something else. And so for me, I know that this is about licenses and not about economic incentives, but I continue to struggle with seeing licenses solve this without discussing the economic struggles.
As Ashley knows, my company, Tidelift, is definitely focused on part of these economic questions, so I 1000% endorse. But I do want to get to, I do again want to echo something that you called out there, Ashley. I think there's Sammy and I were talking about this Hippocratic license draft a few weeks ago, and something that he said that really resonated with me, right? Like there are a lot of, again, in this moment of increasingly hypercharged awareness of, you can call it late capitalism, or you can just call it the post-Trump reaction, or whatever you want, right? Like there are a lot more people thinking about like, how am I contributing to bad in the world, right? And the Hippocratic license, regardless of what else one might think of it, right, is a way for a developer to say, you know what, I can't necessarily control much, but I can at least control this, right? I can make a clear statement and attempt to use the legal system to support that, look, I like putting code out into the world, but I don't want it to be used for these bad things, right? And that is, in a sense, very empowering, right? But it gets to this thing that Karen was saying earlier about or that Karen was hinting at, and I mean, whoever sourced it originally, who is being freed by this, right? Is it users? Is it developers? It's not a bad thing to provide developers with a way of saying, I can only control so much in the world, but this is a thing I can't control. I want to control it. I want to make a statement. If there's not adoption, the actual impact on users, like if we're just doing a thing that empowers developers again and doesn't actually help, if we don't actually get adoption, then we're not helping users, right? And I really struggle in the Hippocratic context with this challenge of, if we're just publishing software that like really means well, but like doesn't, I mean, pick your point. Like, I mean, my personal pet peeve is, carbon, like we use all this free software to more efficiently identify oil wells that we can drill and extract carbon into the atmosphere, right? Like I can write a license that says you shouldn't use it for this, but at the same time, if it's not actually if that software is just blocked at the door by anybody even vaguely tangential to carbon extraction, have I actually like made any dent in the world, or have I just like yet again performatively said, well, I don't like carbon extraction? You know, I mean, this is a challenge with all activism, right? Sometimes I want to like get into the room a bunch of like experienced carbon activists and license and software people and say, we need to learn from each other because this sort of bifurcated thing just isn't working. And again, excited about the accountability labs work in that direction.
Yeah, and so to kind of add to Ashley's point, like I think that one, obviously I understand that there are economic concerns with it, and the goal isn't to not care about adoption at all. It's that it wasn't one of the primary goals when developing the license, and we still want developers to be paid, but there is a little bit of a push and pull with the fact that ultimately, if you're adopting this license, you're saying there are certain limits to what it can be used for. Now, as far as reducing costs for developers and maintainers so that they can have some sort of access to legal resources. That's part of the reason why this job was developed, why literally the ethical IP program was developed at Cal, was for me to provide, or whoever would have been in my position to provide resources to developers and free legal services. So I'll go ahead and I'll throw my email in the chat, and I'm happy to provide any free legal services to software developers or maintainers who have questions about adopting ethical licensing and how it might impact their projects specifically, and whatever I can do for you in that aspect, I will. And so please reach out, and if you have questions about adoption, definitely let me know so I can at least somewhat help the economics as well as as well as just trying to make the world a better place with ethical licensing, understanding the practical side of things, and hopefully reducing your legal costs.
Karen, did you want to jump in on that?
I don't have anything to add, actually.
Okay, great. So I will give it one more call for additional comments or anything in the chat or hands before we call it there. Going once, going twice.
I did want to jump in really quickly on a question
please.
that Mitch posed like very early on, that, and I know Mitch isn't currently in because he said he had to go, but he did talk about what the value was of having additional parties sue for copyright infringement. And I just wanted to clarify that that's not quite how the Hippocratic license functions, right? It's that it creates a duty of care through negligence law. And so if somebody were to, if somebody was in a supply chain and was enslaved by another organization, and that organization then supplied goods to a licensee, then they could sue the licensee under negligence law, but use the license as kind of showing why there's this affirmative duty of care. So they wouldn't be suing for copyright infringement. They'd be suing for negligence, but using the license to show that there was an affirmative duty of care by the licensee to the person harmed.
Oh my gosh, we should schedule a whole nother panel on like the functioning of these kinds of licenses and the kinds of actions that could be brought that haven't been brought currently. We should totally do that.
Yeah, there's no license engineering panel to be or conference to be had, right?
That's fantastic. Yeah, I see Charity with her hand up as well, who's from Cal, which is our other fantastic co-organizer. So I want to give her a chance to weigh in as well.
Great, thanks, Michael. Just on that same last point and what Mitch raised, this question about what's the inherent value of these licenses. There's also been questions raised at various points about redundancy with anything that is criminally prohibited, right? I think as an international human rights litigator, we see that it's actually really difficult for a victim of a corporate human rights abuse overseas to successfully bring a claim in US courts under ordinary tort law or under federal legislation that we have. In fact, recent cases, including Doe v. Nestle, who was just a Supreme Court case last term, made it really difficult for anyone to bring a case where the harm is extraterritorial. So if the corporation violates human rights outside of the United States, it's really hard for these folks to bring claims within the US. And so part of the reason that Cal got involved in ethical licensing is we're really trying to diversify the tools that are available. It's not at all redundant. In fact, there's so little recourse available to these victims that this is like a sort of wild attempt to find one other possible way to get some kind of remedy for victims of egregious human rights abuses in global supply chains. So that's just to be clear that it's really not redundant, nor is there like a question about value add. Any other way we can get this kind of recourse for victims is really important. Just wanted to throw that in there.
That's really interesting to hear. Thank you for sharing that.
Yeah, it's fantastic to hear that on the broader challenges of accountability for human rights violations, which I very much defer to Charity in her understanding of, as she has an incredible knowledge of that space. So I think that's potentially a good place to end it for today. I will thank all three of our panelists. I will do a quick plug for our final panel in this kind of mini series, which will take place tomorrow at 12 p.m. Pacific time, so same start. And at the same Zoom, at the same links to join as well, to make it nice and easy and convenient for folks. The panelists will be Sarah Pearson from Creative Commons, Coraline from Organization for Ethical Source, and Stephen Laporte from the Wikimedia Foundation. And the session will be moderated by Nathan Schneider from the University of Colorado. The topic of that will be the ethical stack, which was sort of alluded to in some of our conversations. So I think it'll build very naturally on what we said here today. And before we go, I will give one other very small, quick plug for a couple of other events that we have next week. On Wednesday will be the fourth and maybe final, haven't decided yet, installment of our Ethics in Tech series on, actually probably won't be final. I think we're going to do it. Well, we'll see. The next Wednesday, we have the next installment of our Ethics in Tech series featuring Dunstan, Allison Hope of Business for Social Responsibility, talking about challenges to promoting ethics and responsible conduct within the tech sector. And on Friday, we have a session on calibrating data surveillance, including Ron Dewart of Citizen Lab and a bunch of other fantastic speakers to talk about appropriate regulatory postures to novel surveillance technologies. And in the first week of November, we just launched a fantastic 5-day event on power and accountability in tech, featuring Sarah Roberts from UCLA, Alex Hanna from Google, David Kay, the CEO of ICANN. It's a fantastic lineup that I'm personally enormously excited about. So you can find links to register for those in the chat. And with that, I will say thanks again to our three incredible panelists who I really enjoyed this conversation. And I'm very much looking forward to tomorrow's wrap-up event. So see you then.
Thanks for having us,
very
Mike.
much.